present. Start with audience comments.
Just real quick, last week I had mentioned for the intersection where you guys were adding the stop signs, and I know that a few of you even mentioned that you want to strongly consider turning that into an all-way stop anyway. I just wanted to let you know that I went by there, and I wasn't expecting this, but I was actually just looking at things the next day, and exactly what I thought could happen would happen, which is because I'm coming down the side street and don't have a stop, somebody sitting at the stop sign as I went to turn thought I was supposed to stop and started to go, and I had to slam on my brakes to not get in an accident. Not slam, that's exaggerating, we're not going that fast. But either way, so it's not something that's going to happen daily. I mean, Mark and I were just talking about it, and as people get used to it, things will change. But I just wanted to mention so you guys knew that there is that definite potential, and my only interest is that I don't want us to have a dangerous intersection created that way. So just something for you guys to think about as you guys decide if you want to do that next month or whatever you want to do. And then the only other thing I wanted to ask was the item that's on the agenda tonight for the Open Meetings Act presentation. Will that be open to everybody?
No.
Okay. It's just open. We won't get to watch, or we just.
Oh, absolutely. She's here.
Right. But it won't be open to any questions that might come from the audience?
No.
Okay, is there a reason?
It's not open to the public.
Okay.
She's on the agenda.
Sure.
That's the reason.
Okay, I just thought there might be good questions come up that you guys want to hear answers to. Anyway, that's all I have.
Okay. Any other audience comments?
I just have a question. Did we ever decide, or do you guys know when Lotus is going to be paved from Indian Hill all the way to the stoplight?
Next year.
Is it? Okay.
Yes. Got a community block grant to do so.
Okay, thanks.
You're welcome. Any other audience comments? Okay.
Excuse me, I'm sorry. I'd just like to thank the board and all the residents that supported that stop sign. It really is working. It's good.
You're welcome.
Just like to thank you guys.
You're welcome. Okay, under administration, we have presentation of a seminar on the Open Meeting Act by the Lake County State's Attorney's Office. Today we have with us Janelle, Christensen, correct?
Right.
The Lake County State's Attorney's Office. After a previous village board meeting, I had met with a trustee in my office when another trustee walked into the office. I continued the conversation with two trustees in my office. This was a minor violation. Ms. Christensen is here to give us a presentation on the Open Meetings Act, and I ask everyone to give their undivided attention.
Great, thank you.
You're welcome.
Usually I stand, but I've got a little bit of a cold, so I think I'm going to sit tonight if you don't mind. And I have some extra handouts for people in the audience. You feel free to take them and follow along if you like. I've got a bit of a cold. If you hear me coughing, which eventually I will do, don't worry, I will get oxygen. Complete strangers have told me to go to the doctor. I've been. Just can't stop coughing. First of all, before I start, I want to thank you, Mayor Lumpkins, for being so cooperative in our investigation of this matter. I really did appreciate it. I appreciate your candor, your honesty, your straightforwardness, your willingness to just say the facts as they were and help us in our investigation, because that helps tremendously. In my experience as the Open Meetings Act enforcement officer, if you will, for the State's Attorney's Office, most violations of the State's Attorney's Office of Open Meetings Act fall in one of two categories. But there's always the exceptional few that are troublemakers, but for the most part they fall in two categories. Either one, the people on the public bodies just simply don't know the act, which happens sometimes. I had a public body once that was shocked to find out that they had to post the agenda on both their principal place of business and the location where the meeting is held, if they're in two separate areas. They didn't know that. For 10 years, they'd never done it. It's just they didn't know. So that's why training comes in and is very helpful. I think the second category of your typical violations come at a point where a quick decision has to be made, and it just ends up being the wrong decision. And for those folks who fall in that category, you're in good company. I have another board right now involving an attorney. And he attended the board member, and he was the one who made the snap decision, and he was the one who made the wrong decision. So people who are very familiar with the act can also sometimes go astray. And so that's why, as the State's Attorney's Office, we like to come out, when we've had a situation or a matter come up where we come out and we do some additional training, and we assume that that'll solve the problems, and it's always good for everybody to have a little bit of a brush up on the act. So with that said, as we go through, sometimes I do this on PowerPoint. Your attorney told me that you guys didn't really have access to that kind of technology, so I printed out my PowerPoint, and you can just follow along as you go along. Before I went into working for the state's attorney's office, for a very long time I was in private practice. And one of the first things I did was workers' compensation. I represented the employer. And as a young attorney, I found it so frustrating that I always lost, and that the employee was always compensated. And a very wise, more experienced attorney than I took me aside and said, Janelle, it's called workers' compensation for a reason. You know, the name of the act has meaning here. Don't feel bad, you keep losing. With the Open Meetings Act, it's the same sort of philosophy. It's called the Open Meetings Act for a reason. The title tells you the purpose of the act. The purpose of the act is to allow the public to hear your deliberations as a public body on public business. We like the sunlight to shine in so that the people in your community can come here and listen to you make certain decisions. The act is construed strictly. So from the states, we're going to talk about certain areas of the act. There are bright line areas of the act that without a doubt, the rule is the rule, and there's no ifs, ands, buts about it. There's other areas of the act that are a little bit grayer, and we'll talk about some of those areas. But from the state's attorney's perspective, and I think from the attorney general's and from the judge's perspective, when we're analyzing the Open Meetings Act and how it applies, we take the most conservative, strictest construction, and we always err on the side of openness, because that is what the courts have told us we have to do, is to make certain that the public has the right to hear what they have the right to hear. So the rule. The general rule, it's on the second page here, is that all meetings of public bodies shall be open to the public. Now, if the rule stopped right there and there was a period, it would be so easy to apply, because everything that you did would have to be conducted in the public. But as you know, the rule, that's not the rule. It's actually, you are given the opportunity under certain exceptions to go into executive session and discuss certain matters in closed session outside of the hearing of the public. And those are set in subsection C. We're going to talk about some of them. And that you also know that in order to close those meetings, you have to follow the procedure that's set forth in section 2A, and we'll talk about that again in a minute. So all meetings of the Act are required to be in public. They must be held at specific times and places which are convenient and open to the public. I like to analogize the Open Meetings Act to a party. You have to send out an invitation. And on your invitation, you have to say the time, the place, the date, and what the party's all about. And that's what you, as a public board, have to do in order to comply with the Open Meetings Act. And we'll talk about it again as we go through, but that's the purpose of the notice and the agenda, so that the public is notified and has the right to decide whether they want to come or not. I will give you some examples of open to the public. I had a situation where one of my public bodies was held, it was a library, the library district, and they wanted to hold their meeting on a Saturday morning at 8 a.m., and their plan was just to go straight into executive session, and there was going to be no public discussion like we're having now. And so the library called me up and said, okay, well, our meeting's at 8 o'clock, but the library doesn't open until 10. But since we're just going to go into executive session anyway, do we really have to open the library? Because it's going to be a real hassle for us, because the public's not going to understand that they can't go into the library. And the answer is yes, yes, yes. Otherwise, the meeting is not open to the public. Even if you're going straight into executive session, you have to, just like you have tonight, the doors have to be open, the public has to be allowed to come in, and then you can close eventually to go into executive session, but the meeting has to be open. I had another situation where the normal place where they held their meetings, they couldn't have it there, so they rescheduled it in another location, in a historic building on the second floor with no elevator. Well, that's not really open to the public, because we have certain persons of the public who are handicapped. And although, you know, there was a lot of moaning and groaning because they didn't believe anybody who was handicapped was actually going to come to their meeting, that's not the point. It has to be open and convenient to the public as a whole. We've had situations before where there's very, very hot topics that are going to come up. and you know that you're going to pull a lot of folks in from your community, and you know that you're not going to be able to fit them in this room, then you have to have a conversation with your attorney and talk about, should we hold this meeting someplace else? If we know we're going to have 500 people, 200 people come to this meeting, is it truly open to the public if we can only fit 25 people in here? That's a conversation you have with your attorney. But you have to think about these things in terms of it being open and accessible to all folks in your community. A public body, I think you guys, we don't really have to go over this section. I think you all know that you are a public body. You are the Village of Round Lake Heights. The definition of a meeting. Now, if you haven't looked at the Open Meetings Act statute in a while, it has actually been revised. It was changed in January of 2007, and then in June of 2008, this summer, it was also amended. And the definition of a meeting was specifically amended by those 2007 amendments. And the legislature took the definition of a meeting to clarify that a gathering doesn't require a physical presence. We're all here gathered together physically, and we are all here physically. But the Open Meetings Act contemplates that with technology that we have today, it's possible to have a gathering of you folks, even if you aren't all physically present. We could have a gathering if you were all talking on the telephone. We could have a gathering if you were videotaped. We could have a gathering if we were communicating by electronic means. And the statute specifically talks about electronic chat and instant messages, or other means of contemporaneous interactive communication. That's one of those gray areas that we're going to talk about in a few minutes in terms of what is exactly meant by contemporaneous interactive communication and how does the State's Attorney's Office interpret that. But for the purpose of a meeting, if you come away with nothing else today, really think of it in terms of three parts. A meeting is a gathering, and we'll talk about that in a minute, what a gathering means, of a majority of a quorum to discuss public business. In order to fall under the Open Meetings Act, or to inadvertently violate the Open Meetings Act, you have to meet all three of those. You have to have a gathering, you have to be discussing public business, and you have to have a majority of a quorum. The last part is the brand new section that came in just June of 2008. It doesn't affect you. It really only affects 5-member boards. A 5-member board, they can never talk to each other because a majority of a quorum is 2. So literally, a 5-member board could never talk, even one-on-one, without violating the Open Meetings Act. And the legislature, there was a lot of pushback on this because there are quite a few 5-member boards. And it was decided that truly that wasn't fair. So the act was specifically amended to allow 5-member boards to have the ability to at least have conversations between 2 folks without violating the Open Meetings Act. I would have you know, though, that there is a slight discrepancy in that amendment in that it only applies, as it's written now, to 5-member boards. So then, of course, who came next? The 3-member boards. And the 3-member boards said, well, hey, what about us? How come, technically we can't talk to each other either without violating the Open Meetings Act because of the majority of the quorum. But as it stands right now, it doesn't apply to 3-member boards, it only applies to 5. So the reason I bring this up is if you have subcommittees. So if you have subcommittees and you have subcommittees with 3 persons or less, you can't talk to each other. You can't. Well, we'll get to that in a minute, but you can't talk to each other without violating the Open Meetings Act. Keep that in mind. All right. So a gathering, majority of a quorum to discuss public business. Majority of a quorum. I'm pretty sure you're all familiar with that. You are a 7-member board. Your quorum is 4 members, which is half plus 1. A majority of a quorum for purposes of the Open Meetings Act is half plus 1 of your quorum. So 3 is your number for Open Meetings Act. 3 means that anytime there are 3 of you and you're gathered by whatever means and you're discussing public business, you can only do that if you have set up a meeting and an agenda and notice and it's open to the public. Otherwise, you are going to potentially violate the Open Meetings Act. And let me give you an example of a board who completely, just inadvertently violated the Open Meetings Act. It's one of those things where you're not thinking about it in the context of just your daily living in terms of how you can actually violate the Open Meetings Act. In the situation where it was a board, a 7-member board, they had a lot of outgoing folks, and they had a bunch of new board members coming in. So someone had a great idea. You know what? We should go out to dinner, all as a board. We should go out to dinner, and we should celebrate dinner together and eat together and welcome all these new board members to our board. All right, you got 7 of you, and you're physically gathered, and the purpose is arguably public business because you're welcoming them to the board. You know, good intentions, what is that phrase? The road to hell is paved with good intentions. You know, here's a board who just wants to welcome the new members and make them feel comfortable and welcome to the board, and inadvertently they violate the Open Meetings Act. To them, it was just a dinner, a hello, welcome to our dinner type thing, but actually it was potentially a violation of the Open Meetings Act. And so you have to keep that in mind. Some of you live in a relatively small community. You probably go to functions where multiple of you show up. Maybe it's the Christmas party, maybe it's a wedding, an anniversary, a party, whatever. If 3 of you are together and you end up by the bar with a glass of beer and you're chatting about public business, you just violate the Open Meetings Act because you're not allowed to do that. Now, on your board, with your 7-member board, it is perfectly fine, and sometimes the public doesn't understand this, it is perfectly fine for a one-on-one polling. So let's say the mayor decides to talk to Andrew Walker about public business. Okay, public business, you're going to talk, you're going to have a gathering, we'll have your gathering by telephone. That's fine. Remember, a violation only happens when 3 of you are discussing public business. 2 of you can absolutely always one-on-one discuss public business without a violation of the Open Meetings Act. It's when you bring in that 3rd person into the gathering that you potentially violate the Open Meetings Act. Excuse me. One of the easiest ways, we'll kind of flip through here, the exception of the majority of the quorum we already talked about. And this is where we get into potential pitfalls again in terms of violating the Open Meetings Act. As a board, one of the things that you have to think about is just the public image that you are presenting. Because remember, you have to have all 3 factors. You have to have a gathering of a majority of a quorum to discuss public business. So let's say 3 of you just coincidentally bump into each other at the grocery store and you're chatting about your grandson's birthday party. You have 2 of the factors, but you don't have a 3rd factor because you're not discussing public business because your grandson's birthday party is obviously not public business. So if someone came to me and said, I saw the 3 of them talking in the grocery store, now I have to do an investigation. Now I got to call you up and I have to say, okay, the public has complained that there were 3 of you that violated the Open Meetings Act because you were seen in the grocery store talking about the produce section. What were you talking about? And so again, it's one of those things where it's the public impression. Did you violate the act? No, you didn't, because you weren't talking about public business. You were talking about your grandson's birthday party. But you as a board need to be cognizant of the impression that you are leaving with respect to those people in your community. If you get into a situation where 3 of you are gathered together, even something as innocuous as talking about your grandson's birthday party in front of bananas, just have one of you walk away. Just have one of you walk away and just say, you know what? Even though we're not talking about public business, it's not worth the impression that we could be leaving to the public. I'm just good. I'll see you later. Meet me up in pasta, if you still want to talk some more or something. So even though you didn't violate the act, from the public's perspective, it seems that you could be violating the act. And I have one community in particular where it's a contentious board and it's a contentious community. And it's a very tight community where literally they all live in the community. And I get phone calls all the time. I saw the 3 of them swimming in the lake, together, in the middle of the lake. And I know they're talking about public business. And so I call them, I say, guys, don't do that. Just don't do that. You know what I mean? You're causing yourself nothing but problems. All you're doing is perpetuating the dissension within your community to begin with. I know you're telling me that you're not talking about public business, but as a board member, you got to think about the impression and what the public is thinking. So just simply don't do it. One of the other biggest pitfalls, which your attorney tells me is not a problem for your board, is emails. And this is where we get to the language in the statute that talks about a contemporaneous interactive communication. And I had attorneys say to me, well, an email exchange is not a contemporaneous interactive communication because maybe I email Mike and then Mike emails Andrew and then Andrew emails Jeff, but there's a big gap, maybe there's 2 or 3 days in between that. That's not a contemporaneous exchange. As I told you before, this is one of those gray areas that the state's attorney's office takes a very strict line with. And from our office perspective is that you can still violate the Open Meetings Act. And I just recently had a situation involving a public body where this happened. It's our perspective that it's the communication, not the timing of the communication, that's critical. So for example, in this situation with this community, we had, it was a 7-member board, and we had, they're trying to get ready for a meeting. And again, good intentions, they're trying to be organized and get ahead of time. So you had one board member send out the topic that was going to be discussed by the board. And they said, this is the topic, you know, these are the issues. And then it was just a mass email. One board member emailed her back. So now it's board member, one email exchange. And this board member said, oh, Susie, this is what I think, blah, 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 about all these issues. So then Susie took that email exchange, and apparently then she individually, by telephone or by email, I didn't get the whole exchange, so I don't know, talked to another board member, and then another board member. And then Susie took the email from the first board member, and then she summarized her conversation with the other 2 board members, and then she copied the entire board and said, okay, you guys, you know, I think we have a consensus. We have our meeting set up for this next week. This is what you said, this is what you said, this is what you said, and this is what I think. What do you think? It's not contemporaneous. The actual exchange took almost a week and a half to complete. But from the state's attorney's perspective, remember the whole purpose of the Open Meetings Act is to have deliberation in public. The public is supposed to be hearing that deliberation, not conducting that deliberation behind closed doors and emails of exchange. And from our perspective, it was a violation of the Open Meetings Act because we did have an exchange going on with the gathering of a majority of a quorum discussing public business. And had a little bit of fight with the attorney in terms of the definition of contemporaneous exchange, but eventually he agreed with me because I told him I'm going to win that one. I'm dying for you to tell me. I'm dying for you not to agree with me because I want to make case law because I know I'm going to win that argument. And I know that there is no judge who is going to find that you can have that kind of exchange by email behind closed doors because it's not contemporaneous. So, as I said, I told your attorney I was going to get on my soapbox about email with you folks. And he said email's not a problem with you guys because apparently you don't email that way. But, God darn it, I feel obligated to say it. Because email is something that we all do, and you just have to be careful. You have to be so careful with email. And you email your comments to him thinking that it's just going to be private, and the next thing you know, it gets passed on to the world. So our recommendation from the state's attorney's office, even though you guys don't do it, is don't do it. Don't do it. That's the easiest. That's the easiest way. Just don't do it. If you have to do it, I mean, we have some boards that are very, very large. And it only makes sense for an administrative type person to say, hey, everybody remember we have a meeting and here are the attachments. That's fine. Just simply don't do it. Another board I had was a very contentious board. They did not get along well. They were constantly fighting. There were factions within factions within factions of the board. And they would have very, very contentious meetings. And what would happen is they would leave the meetings, they'd be hot, they'd be angry, someone would go home, they'd have their glass of beer or tequila or whatever, and they'd sit by their computer and they would send out a scathing email to every person on the board. I think this about you, and I think this about you, and I thought that was stupid, and I can't believe you said that, and you're all blah, 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 blah. And at the bottom of it, they would write, they wrote, do not respond to this email, or you will violate the Open Meetings Act per the state's attorney's office. And then they'd send it to everyone. You know what? Okay, that's not necessarily a violation of the Open Meetings Act, and that, again, it's my one-way exchange with a group as a whole, but you are begging the board to violate the Open Meetings Act, because when you sit at your computer the next day and you open up that email and read it, you're going to be mad. You're going to be furious. And the natural reaction is to, so don't do it, is to whiz off a response to somebody else. So, again, just don't do it. That's the simplest solution, and you won't run afoul. And you always think, oh, email, no one's going to get my email. You get a board where the board doesn't get along, and then that's how I get my email exchanges. I do a presentation like this, and then a board doesn't get along, and then the next thing I know, I have a board calling me up, hey, our board's violating the act. Here's the email exchange. And then I have it. Once you write an email, it's forever. So just don't do it. That's again, my best and strongest advice to you. If you guys have any questions as we're going along, feel free to interrupt me. I like doing an exchange as much as possible. So even though I'm kind of on my pre-planned roll,
I
speak
have
up.
a quick question.
Sure.
The incident that brought this about, so I just wanted to say, like, with me and the mayor having a conversation after a meeting, if another board member does approach the office and come in there when you are talking about something,
One of you has to walk away.
so you would then immediately say, hey, look, we're talking about, you have to wait out in the hallway or something.
Yeah, exactly.
Okay.
So, I mean, that's one of the situations. You know, two of you are having a conversation, the third one joins in, you're after the meeting. You know, you're not thinking that you're still in the meeting. It's easy to violate.
Right.
So you just have to remember, if two of you are talking, which is absolutely fine, a third one joins you, somebody has to leave.
Okay.
Otherwise you violate the act. If you're talking about public business. But again, here goes the idea in terms of impression as well. Let's say it's after the meeting and you're all talking about your plans for the weekend and you've congregated, you know, around the water cooler. Again, you have to think about the impression you're leaving with the public. If the public sees that you folks are either gathered before the meeting or after the meeting, their impression is that you're discussing public business. So it should be your practice to simply not to do it. That's the easiest way to handle that. The next category is remote attendance. This was one of the newer changes to the Open Meetings Act that came into effect in 2007. The legislature recognized finally that we are now a mobile society and that lots of folks who sit on boards travel for business or there's a family illness or there's a personal illness and they want to be able to call into the meeting. In the past, you could always call into the meeting, you could listen, but you couldn't participate. You couldn't attend the meeting. You couldn't actually vote if you were calling into the meeting. Under this new statute, this amendment, you can actually do that now if your board wants to do it. This is an optional provision in the Open Meetings Act. The Open Meetings Act leaves it optional for every single board to decide whether they want to adopt this particular provision or not. If you decide that you do want to adopt it, you actually have to, you talk to your attorney and you can pass some sort of resolution agreeing that you're going to follow this. So let's say I'm on the board and I'm sick and I decide, oh, it's a really important issue and I really want to attend. I'm just going to call in tonight. Well, I can't do that unless the board has already agreed that you're going to allow that to happen. And it's under limited circumstances. It's a personal emergency or disability, employment purposes, or a family or other emergency. So I had one board where a woman had a daughter in boarding school and she liked to go up and visit her. That doesn't fall. I mean, the statute is clear. You have the 3 exceptions that you're allowed to invoke this remote attendance, and having a daughter in boarding school out of state just doesn't count. So it's read, it's construed strictly. I understand that supposedly in the works, in the pipeline, there's going to be an amendment to allow vacations to also fall as an exception. But as it is right now, that has not been changed. If you're going to allow the remote attendance, you still have to have a quorum at least present. We don't want everybody calling in. That would be problematic. And again, you have to pass an ordinance to allow yourself to do it. All right, closed session. We talked about that in the first part of this presentation, in that there are 24 exceptions to the open requirement that allow you to go into executive session. The good thing is we're not going to talk about all 24. There's no need for us to go through them one by one. They are very specific, though, and again, they are construed narrowly. So if you think you have a topic that is going to fall potentially in executive session, look at your statute, because if it is, it'll be listed there as one of the exceptions. I'd like to start out by saying, please notice that there is no exemption in the Open Meetings Act that allows you to go into executive session to talk about a contract and how unhappy you are with that contract, or to talk about going into executive session to talk about whether you should enter into a contract with one contractor or another. There is no exemption. That's exactly the conversation that you're supposed to be having open here in the public. Now, let's say you have a contractor who did a really bad job, and you're thinking about suing him. Then you can go into executive session, as long as you indicate on the record that litigation is imminent. The litigation prong is two prongs, and this is the one I think public bodies most often screw up, is that there's the pending litigation. So if someone has sued you, or you've sued somebody else, and the lawsuit's actually been filed, that's easy. You say in executive session, we have pending litigation. The one that's the trickier one to apply is the one where litigation is imminent. Because if litigation is imminent, you actually have to put on the record the basis for why it's imminent. It's not imminent if you're just sort of unhappy with the contractor. It's imminent when you're really unhappy with that contractor and you've got your attorney with you to talk about whether you can sue that contractor and what are the ramifications going to be to you as a public body if you sue them. That's imminent. And so, you know, I had one situation where there was a public body that had a lawsuit and they entered into a settlement. And there were certain provisions that had to be completed by the public body in conformance with the settlement. And one of the provisions in the settlement agreement said that if these provisions were not met by the public body, that this individual had the right to refile his lawsuit. And of course, you know, as litigation goes, there were some issues in working out exactly what the public body had agreed that it would do. And so the public body wanted to go into executive session to talk about that. And the public said, you can't, there's no pending litigation and there's no imminent litigation. And they went to executive session anyway. And long story short, you know, they did not have a basis to go to executive session. Even though there was a clause in that contract that said, if you don't comply, we can resue you. That's not imminent. That's not imminent. You have to be really careful with that exception because that is the one that is most often screwed up. I will tell you what our typical resolution as the state's attorney's office is when something like that happens. If a board goes into executive session and there's a dispute in the public as to whether you as the board had the right to go into executive session, the first thing I do is I talk to your attorney. And then I tell your attorney, I want to listen to that tape. And I want it transcribed. And then the transcription of the executive session comes into my office. And then I look at exactly what was said by everyone. And we make a determination in our office whether it should have been, the conversation should have been held in public or whether it was properly held in executive session. Or sometimes we get piecemeal. Some things were properly in executive session and then folks segued into topics that weren't really related. What we'll do as the state's attorney's office then is we'll shuffle it out in terms of those things that should have been executive session were properly executive session. That transcript remains confidential. But those parts of the transcript that should have been conducted in public, we then require the municipality to post them. And so in this case, with the municipality and the imminent litigation, we required them to, after the fact, go back and post that whole conversation in terms of their discussion about what they were and weren't going to do because we didn't find that the exception applied. So that's how we typically resolve those situations. If you have any questions whether an exemption applies or not, you should call your attorney ahead of time and just double check so that you're extra cautious. Sometimes people get in executive session and they feel free that they can talk because the public's not listening. But, you know, if you're not positive that you have the right to go into executive session, you should talk to your attorney first. Other types of exceptions, especially that deal with municipalities, are real property, discussion of closed session minutes, which we'll get to in a minute. But so, you know, you've got the 24, you can look through them. There is a specific procedure for closing a meeting to go to executive session. You cannot do, as one of my boards famously did, okay, we're going into executive session. Everybody out. That's not how you go into executive session. You can't do it that way. There's a procedure that has to be followed. First of all, you have to have a quorum present. If you don't have a quorum present, you cannot go into executive session. When you're in open session, you have to actually cite the exemption that lets you go into closed session. Now, a case just came out this week, the first open meetings case that's come out in a while, where the courts have again clarified, you don't have to say exemption, we are going in under exemption 5 ILCS 120/2C subsection 1A. You don't have to be that specific. It has to be specific enough that the people in the audience can know what exemption you're falling under. So, for example, if you're saying that you're going under real property, well, there's really only one real property exemption. You say real property, you're good, you're covered. You fall into the litigation exception, though. We already talked about this. You better specify whether it's pending, where it's actually filed litigation, or whether it's imminent. You have to be specific. Then a vote has to be taken where you folks have to agree to go. There has to be a majority of you that agree. The public has to know who wants to go into closed session and who doesn't want to go in closed session. Then, and you're supposed to only go in on your specific topics that you've identified in open session. And I would say this is the #1 thing that happens. People groups go into executive session, and then when they get there, they're like, oh yeah, you know, there's that other topic that we're going to talk about in executive session. And then they just talk about it. You can't do that. If you haven't already identified your bases for what you're going to be talking about in executive session, then you have to stop, you have to go out of executive session, you got to come back in here, and then you have to start the process over again. You have to identify the additional bases that you're going to discuss in executive session. You have to identify the reason, you have to take a roll call vote, and then you can go back into executive session. Once you get back there, it's not a free-for-all where you just be able to talk about, again, whatever you want to talk about. You're limited to what the exemption actually applies. And I would say that's the second most violated occurrence that happens in executive session. You know, we're all humans. And as humans, we can be tangential. So you get on your topic that you're supposed to be discussing in executive session, and then I've seen many transcripts where people go far afield of the topic that they actually went in to discuss. So it's your job, each and every one of you as a board member, to be paying attention to your topic you're supposed to be talking about. And if one of your co-board members goes astray, you say, hey, we can't talk about that. You know, we can only talk about what we came in here to talk about, and this is the topic. Let's stay on topic. One of my favorite stories about doing these meetings is, again, after I did this whole presentation and went through this whole recitation like I did with you, I said goodbye, and I said thanks for coming, and then the attorney told me that right after I left, the board said, all right, let's go into executive session. They did not listen to anything I said. So if you come out with nothing else from this meeting, remember there's a specific procedure that you have to follow in order to actually go into executive session. Once you're in executive session, you can only talk about the topics that were specified in open session. Executive session is for discussion only. No final action may be taken in executive session. All final action must be taken in open session. I would say one of the other questions that typically comes up, and was just recently addressed by that case that came out, was, all right, let's say you have your agenda posted, and before the meeting, an employment issue comes up, and you need to talk about it in executive session, but it's not on your agenda. Can you still go into executive session even though it's not on your agenda? And the answer is yes. Because remember, the agenda items are items that you are going to discuss and potentially take final action on. You can only take final action on items that are specifically listed in your agenda. Closed session, you're not supposed to be taking final action. You're barred from taking final action. So if you have a situation that comes up, and you find that you need to talk about it in executive session, and it's not listed on your agenda, you can do that, provided you follow the steps that I already told you. You have to tell the public you're going to executive session, you have to give them the reason, you have to take your vote, and then you can go into executive session. The other question that I think typically comes up, since I'm on this a little bit of a segue here, talking about being tangential, is can you talk about something that's not specifically listed on your agenda? And the answer is yes. If you have an item that's not specifically listed on your agenda and it's something that you want to talk about and have public discussion, yes, you absolutely may talk about it. You may not, however, take final action. If a topic comes up that's not on your agenda and you talk about it and then you're ready right then and there to take final action, well, you can't. You have to wait until your next scheduled meeting that's been properly noticed and had the agenda posted, and then at that meeting you can take final action. Once you're in closed session, back to the topic I was actually on, you have to keep minutes and tape recordings of your closed session. As the state's attorney, I am very favorable to this requirement that you have your tape recordings, because it's a great device for me to come in and regulate and act as enforcement for my public bodies. Because now I know exactly what happens in your sessions, because I get to hear them. You have to keep your tape for 18 months. So when you go into executive session and you have your tape recorder running, you must keep that tape for 18 months. You may not dispose of that tape until a couple of things happen. One, you have to have approved the minutes of that executive session, and you have to have agreed to release those minutes to the public. And you have to have voted on that to happen in closed session. So once those things happen and 18 months have passed, then you can dispose of it. You can't just automatically, where you're going to run afoul is if you just have a ticker where your administrative clerk says, okay, we're 18 months from the date of the public meeting, erase them all. Can't do that. You have to follow the procedure that I just mentioned before you can get rid of those tapes. My recommendation to you is that once you've met those requirements, get rid of the tapes. You know, there's no reason to be keeping those tapes after you have the ability to get rid of the tapes. After you follow the statute and you've approved the minutes and you've released them and there's no reason for it to be confidential anymore, get rid of the tapes. There's one lawsuit out there where it talks about the ability of the public to get those tapes. Excuse me. It was an employment matter, and she filed a suit in federal court. And she said, I want those tapes in executive session because I think they're very pertinent to my employment discrimination matter, and I would like to know what that board talks about in executive session. And it was a federal court case, again, it wasn't a state court case, it was a federal court case. And in that case, the federal court said, you know what? Those minutes might be relevant to your action against this public body, and I think they should be produced as part of discovery. There's just that one case out there, a federal case, but that potential exists. So once you comply with the statute, get rid of your tapes. Just have good housekeeping procedures. You are also supposed to, every 6 months, you're supposed to be having meetings where you review your sessions in executive session and you determine whether these matters can now be, whether they still have to remain confidential or whether they can now be released. You're supposed to be doing that every 6 months. Public bodies get behind on that, but you're supposed to be doing that. And you should just, it's like spring cleaning and winter cleaning. You should just set the date and make sure that you do it. And you cover all of those things in executive session. So when you're in executive session, you say, okay, these can be released. This is still confidential. This is no longer confidential. This is still confidential. This, and you go through the list. And you do that every 6 months.
And then it's done in executive session.
In executive session. And you have to do an executive session because if you did an open session, then everyone would know. There was a question recently as to who can attend executive session with you. The act is quiet. It doesn't say people can or can't attend executive session with you. I'm sure if you've ever had litigation pending, your attorney has come back there with you in executive session because your attorney's the one who's giving you advice. And that case that just came out that I told you about, that came out this week, again, confirmed that the act doesn't say yes or no, you can go back to executive session. But certainly, it would seem fair that there are situations where people who are not on the board can go into executive session. And the court specifically decided, one I just talked about attorneys, and it also talked about staff members, that realistically sometimes you have to have people in their executive session who are taking the minutes or helping out administratively that aren't actually part of the board. Notice is the next thing I want to talk about. Again, I told you already, it's an invitation. You have to tell the people where the party is, what the topic is, what time it is, and when it's going to be. Your notice has to be in the form of an agenda, and the agenda needs to be posted 48 hours in advance of the meeting. It has to be posted at the principal place of business, or if you have a situation where you're going to hold a meeting someplace other than here, you have to post notice here, and you have to post notice 48 hours in advance on where that other meeting is being held. So just keep that in mind. I previously had reviewed some of your agendas and was a little bit disappointed in the thinness of your agendas, but just for the sake of this presentation, I pulled up your agenda from the November 11th, 2008 meeting. I'm very happy. It was a fine agenda. It's good. Unlike in the past where I thought it was a little too thin and that people in the public would look at your agenda and have no idea what you're talking about, I thought the November 11th agenda was good. Like, for example, mayor's reappointment. In the past, you folks might have just put mayor's reappointment. Here it says mayor's reappointment, John Johnson, chief of police. That's great. And B, C, D, you specifically list what you're talking about, and that's fantastic. That's exactly what an agenda is supposed to do. An agenda should allow Joe Citizen to pull it up off of your webpage and say, wow, I'm kind of interested in that. I'd like to come. You know, it doesn't have to be a book. It doesn't have to be more detailed than this, but it should be enough that puts the public on notice to whether they want to come or not come to a specific meeting. You guys have your regularly scheduled meetings, so I know that you're doing fine with that. There's notice requirements for reconvening meetings. We won't go over them. I've listed them here. You can read that at your leisure or pull up the statute. Special meetings. You can call a special meeting. If something comes up that outside of a regularly scheduled board meeting that you need to discuss, you can absolutely set a special meeting. You just have to do it 48 hours of notice. One of my favorite stories is where a woman called me up and she wanted to know what was so special about that water pump. And from the state's attorney's office, remember, we don't get involved in substance, we're only procedure. I have no idea why that water pump was so special that they needed to call a special meeting. And frankly, I don't care, because I don't get to jump into your substance. So I don't get to agree whether you should or shouldn't talk about something. I don't get to weigh in on the merits of your discussion. I don't get to throw my 2 cents in whether you should or shouldn't be doing something. My only job is the enforcer of procedure. And as long as you give 48-hour notice and you post your agenda, I'm good. You can talk about whatever you want as long as it's on your agenda. Well, you can take final action on whatever you want as long as it's on your agenda. You can always talk about things, as we said before, even if it's not on the agenda. You can have an emergency meeting with less than 48 hours notice, but it better be an emergency. You know, I've had this come up before. Vacations are not an emergency. So if you have a special agenda item that you want to talk about, and it's December 23rd, and everyone is going to be gone the next day for Christmas, that's not an emergency. Board member availability is not an emergency. An emergency is your 911 system's going down, and if you don't appropriate the funds to solve it, havoc is going to wreak in your community. An emergency is the boiler's about to blow and you need to get a contractor in. Those are emergencies. So just remember this, lack of planning on your part does not constitute an emergency on the state's attorney's part. So keep in mind, it has to be a true bona fide emergency. And don't forget that you have certain news mediums who may or may have not told you that they want notice of any of your meetings. If you do have a true bona fide emergency meeting and you can't get the 48-hour notice, you should give out as much notice as you can. So you should go on your webpage, put notice out, and you should call those news mediums that have asked for a notice and let them know that you will be having an emergency meeting. Minutes, I took a peek at your minutes. They look pretty good to me. You have to keep minutes of all of your open sessions as well as your closed sessions. After your minutes have been approved with respect to open session, they must be posted within 7 days. You'll notice that there is no time frame as to how soon after your meeting you have to post minutes. We read into it a reasonable time frame in the state's attorney's office. So you guys have to know. I took your webpage out. You look like you have a meeting and you get your minutes up, and that's fantastic. I don't have a problem with your minutes. You can read the rest of those at your leisure. And we already talked about reviewing the minutes of closed session. We already talked about destroying the verbatim record. When I went on my tangent, now it's paying off because we're moving along here. And enforcement, we talked about that a little bit. The state's attorney's office actually has enforcement power over the Open Meetings Act, as does the Attorney General's office. If you want any additional information, the Attorney General's website is a great place to go. They have lots of information on the Open Meetings Act. So do we have any questions?
You said you were going to get into committee meetings.
Oh, yes, committee meetings. Thank you. Your committees are also subject to the Open Meetings Act. So if you have committees that are meeting on various issues, they are bound by all of these same rules and procedures. So your committees have to be posting agendas, they have to be putting up their notice. The rules with respect to a quorum apply. If you have a 3-person committee, there's no exception for that committee, unfortunately. So they can literally never talk to each other without violating the Open Meetings Act.
We don't do
Yeah, we don't do
We can get away with that and do a committee of the whole.
Solves a lot of problems, doesn't it?
Absolutely.
It really solves a lot of
And
problems.
it keeps everybody more up to date.
And you know, the other thing that you step away from is a sticky problem that other municipalities of your size have with respect to, some of them like to take 3 board members and turn those 3 board members into a committee. Well, technically, you have violated the Open Meetings Act for the committee as a whole because you got 3 committee members gathered together discussing public business. It's very tricky. Your way is the best way. Just solve the problem. Do you have any other questions? No? All right, well, thank you so much for having me. If you have any questions, any of you, you are always free to call me. One of the things we like to do is we like to give out free advice. So call me with any questions. Some things, if it's a gray area, I may not be able to answer. I may tell you that you need to call your attorney, but I'm free. I don't charge anything.
Janelle, do you have a card?
I do have cards with me. All right, well, thank you so much for having me.
Thank you.
And now don't say when I leave, okay, now let's go into executive session.
Darn.
There you go. You're welcome. Got a million of these, so it's good to pass them out. Oh, you're welcome.
Thank you.
You're welcome.
Thank
Here you go.
I'm not sure if I've seen anything.
Same here, thanks so much.
Take care.
We're in the first one.
Nothing to report, correspondence.
Committee reports, public safety.
Yeah, all I have tonight is citations for the month of October '08. We had 134 moving violations, 15 ordinance, 5 non-traffic, and 4 warning. That's all I have tonight.
Public works.
Okay, then the public website, nothing this evening.
All the trucks and everything are all set, right?
Yeah, as far as I know, Bud's got everything going, everything's, up to par and ready to go.
Lights in the building,
Lights in the building, I didn't talk to him about that. I don't know how far they are.
they're all done.
They are done?
Yep. So if you want to take a peek in there, you should probably take a peek in. It makes a big difference. Building and zoning?
Nothing tonight.
Sewer and water?
I got the cost for the break at Lotus and Town O'Clock, for repair materials and the labor and the curb replacement was $5,408.06. That was done by Schneider. And then also too is earlier this week we had a problem with the lift station at Chesapeake Trail. No cost on that yet. I'll have that next week with those things.
Okay. And that was just actually a rag got in one of the pumps, so they took out both of the pumps, cleaned them both back up and dropped them back in and re-greased them. And I know Manaville was also out fixing by the Tomo trails. They fixed all the sinkholes and different stuff. They were out there the other day. They fixed all the sinkholes down the way. So they are done. So if you have any questions or anybody has some questions, let us know, but it should be completed. Okay. Administration?
I previously reported that Swalco Board had renegotiated with Waste Management on the recycling and how that was going to be calculated, what our payments were going to be. That is requiring all of the Swalco members to do new intergovernmental agreements. And I have received the copies of that, and we should probably put that on the agenda for next month so that we can approve the new intergovernmental agreement and get that taken care of. And that's all I have this evening.
Okay.
Yes.
Ordinances?
Nothing at this time.
Okay. Any old business at all? Any new business? I'll entertain a motion.
Motion.
Thank you.
All those in favor?
Aye.
Those opposed? Motion carries. Try to get right to everyone.